Hello everyone, and welcome to our third pensions video. What we're hoping to do today is cover off some more of the questions that you've sent in through the link that we've set up on our FAQ page. Again, I'm Shay Donald, National Vice Chair, and I'm joined by Alex Duncan, who is our National Secretary. And what we're going to do is just run through a number of questions which keep coming up, and I think we're just going to elaborate a bit more on some of those points, particularly around eligibility, which seems to be causing quite a few issues, and then I'll get onto the form as well. Alex, good morning, thank you.
Hello.
One thing that's coming up is officers are contacting us because they haven't received the link to the actual claim itself. What would you recommend they do if they haven't received that link in their police PNN inbox?
The first thing I would suggest, so every force, the link's gone out to all PNN addresses that we've got. So if you haven't seen it, have a look in the junk email. We know some forces it's landed in the junk email, so just check that first. Failing that, contact your local branch. They'll be able to send you a link.
Well, super, thank you. I mentioned earlier we were going to talk about eligibility. Quite a few questions here, particularly around breaks in pension contributions.
Okay.
So what we're saying is we've got members who are affected because they were previously in 87 or 2006, and then come the 1st of April, they go into 2015.
Yeah.
Yeah. So they're affected, they've got no transitional arrangements, so no full protection or tapering, but through a career break, for example, or maternity leave, which was extended to become unpaid maternity leave, they've got a break in their pension contributions. Can they submit a claim, and are they eligible?
The answer is yes, they can. So they haven't left the pension scheme at any period. They've simply had a period of unpaid time where they weren't paying in because they weren't earning any money. But because they're still in the pension scheme, they're eligible. So yes, they can submit a claim. Okay,
so just to be absolutely clear, if you've had that break, but then you've come back into it, still submit the claim as per the link?
Absolutely. I mean, they haven't left. They've simply resumed paying, so there's no actual break in being a member of the pension scheme.
And what if your query doesn't quite fit neatly into those two boxes? What other resources could they access, or questions could they direct to find out if they also covered?
I mean, look, my best advice to people is, as a starting point, speak to your local branch. They may well be able to help you. We're putting out information, so every time questions come up, we're trying to capture them, and we're updating our frequently asked questions, which we're obviously posting on the website. We're obviously giving updated information to local branches. So I'd start there, and if you don't get any joy or they don't know the answer, they can either send it in to us and we'll look at it and respond, or alternative, of course, there is the pension email address that you can send it into. There have been some delays in responding to all of those, purely because of capacity issues, and because some of these questions, everybody's got different circumstances. Some of these questions take a bit of working out to make sure we give people the best information going. But we've been working through those and sending that information out.
Perfect. And the FAQ document is going to be kept updated with the new questions?
Absolutely. So as these situations arise, so an example of that, which to be honest wasn't covered in the original claim form, where people, they were in the force, they'd then gone off, done a bit of time in serious organised crime agency or the NCA, they'd then come back in, but they've retained their pension throughout, and the form just wasn't set up to capture those kind of histories. Or people who have been through several forces, it didn't capture them. So what we've done is we've got updated versions of the form. So if you find yourself looking at the form thinking this doesn't fit for me, again, speak to the local branch. We've given them alternative forms they can send out to you and assist you with that process.
Thank you. Again, this question keeps coming up. The affected officer saw the writing on the wall looked at the 2015 scheme and went, you know, this is not going to be as good for me as it was when I was in 87, or there may be some who have a view that it wasn't as good as 2006. So they made a conscious decision that they were going to opt out of the 2015 scheme before it was brought in. What about those officers? I mean, they clearly affected. The 2015 scheme was imposed on them, but they've opted out. If they've rejoined subsequently or have opted out altogether, do they have a claim?
Unfortunately not, and that's because when you leave a pension scheme, everybody's treated the same, because once you've left, you're not accruing any pension. So you're not being discriminated against when you compared to another group of people. So you had to be in the scheme to be treated unfavourably. Once you've left, you're not being treated unfavourably. And if you'd had a claim, actually, it would have been at that stage. So if you felt that you'd been discriminated against in 2015, you would have had to have taken a claim 3 months less a day beforehand. If you subsequently rejoined because you thought after a few years, well, do you know what, I need to do something about my pension and my retirement plans, you would have come into the 2015 scheme. But that was the same for anyone that was joining. So you would never have rejoined, even had the 87 scheme continued and not being closed, but then there was a cut-off date, you'd left and rejoined. You'd have rejoined the scheme that was current at the time, which was the 2015 scheme.
So really quite a big difference between opting out and taking a break in pension contributions due to a career break or unpaid paternity.
Yeah, so if you're on a period of unpaid leave, you're still in the scheme. You haven't left the scheme. If you've actively left the scheme, that's the subtle difference. Is if you've left the scheme and then choose to join a pension scheme in the future, you can only join a pension scheme that's open, and that is the 2015 scheme. That's the scheme that's open to new joiners. Whereas if you've just stayed in the 87 scheme, but actually, or would have been in the 87 scheme, notwithstanding you've been moved to the 2015 scheme, which the government accepts because of the transitional arrangements was unlawful, you've never left the scheme.
Okay, perfect. Questions, a lot of questions. We're talking about periods of time of 5 years ago. And a lot of officers are struggling to identify what scheme they were actually on, and for some of us, we actively know whether we were tapered or we were protected or we received none of that. But for a lot of officers, they don't. So how would they actually know what scheme they were on when the new change came in, if they were on 2006 or 87? Is there a way that they can find out?
I mean, the short answer is yes, there is, and I'll deal with that in a minute. But I think in respect to this claim, it's really important that we recognise that the remedy to the discrimination, you don't need to lodge a claim to get the remedy. The government have made it quite clear they're going to rectify this for everyone who was affected. And we will see exactly what that looks like later this month when the consultation period commences about what the intended rectification looks like. But broadly speaking, I think it's fairly safe to assume each individual that was affected will be given a choice about whether for the period in question they're treated as if they were in their old scheme, the scheme that they joined, or whether they wish that period to be treated as if they were in the 2015 scheme. And individuals will be given all the necessary information to make an informed decision in respect to that. This is about being considered for any compensation that a tribunal feels is appropriate for the pain and suffering of the distress. And individuals need to consider when they're signing up to this whether they actually feel they can truthfully say that they suffered this emotional distress. And I say that because if you don't know in truth whether you were affected or not, that might have a bearing on how confident you feel that you can say, well, actually I've been suffering this emotional distress for the last 5 years, or not. So I would just flag that up. In respect of, well, what pension scheme did you join? clearly if you joined before 2006, you would have been on the 1987 scheme. What happened when they introduced the 2006 pension was they wrote to people already in service, and those of us in service will remember you got a very large amount of paper. You were asked to make a choice about whether you wanted to stay in the 1987 scheme or move into the 2006 scheme. It was an individual choice. The vast majority of people stayed in the 1987 scheme, but you will remember receiving all that paper, and I think those people will remember if they opted to move schemes. If you joined from 2006 onwards, or 2006 to 2015, you'd have been in the 2006 scheme,
right,
because that was the scheme that was open for people joining. And then people who joined after the 1st of April 2015, of course, would have gone into the 2015 scheme. But at that time, whether you were in the 87, 2006 scheme or not, unless you were afforded some form of protection, you were also then being moved into the 2015 scheme.
And I think that's where the confusion comes, Alex. I think it's not so much, whether I was in 87 or 2006, it's was I given some degree of tapering? And if I was given tapering, how long was that period of tapering for? And you know what it's like, we're inundated with emails on our day-to-day basis, and I know for things like pensions, we should really be paying a lot more attention. But, I'm thinking back to people who were in this situation in 2012, 2013, 2014,
Yeah.
It's a long time ago,
It is.
and they might have been told, right, you're eligible for tapering for this period of time. How could they actually find out that information? Is there someone they can contact in their own force?
Yeah.
Yep.
Yeah, the best person to speak to is your respective force pension administrator.
Right.
They will be able to tell you. It's also worth checking. Obviously, you should be getting, because it's a legal requirement, an annual pension benefit statement, and have a look at that. It will tell you. But if in any doubt, speak to your local administrator, and they'll be able to give you nailed on what the situation is for you.
Perfect. So that tied up those two questions really nicely. I'm just going to cover another point here about a comment you made, and it's not written down, but I'm going to just bring it in. You said that you don't have to submit the claim because government have said that they'll remedy this pension. If I can count how many times government's made promises and potentially reneged on it, aren't you nervous, or shouldn't we be nervous, that government are just going to say, well, that's all very well, and I do know that they made a lovely statement in the House of Commons in March saying, you don't have to go down the route of civil redress, we will make good this. Can't they just say no?
No, they can't just say no, because obviously through the firefighters and the judges' cases, the ruling has been established that the transitional arrangements, the way they were implemented, was unlawful discrimination. And that discrimination continues. So, people that weren't afforded that full protection when others were, are continuing to suffer a detriment as a result of that decision, which means that the time limitation for taking a claim is still very much current. And what that would mean, were the government, and there is no reason to think they would, but were the government inclined to suddenly change their mind and say, we were only joking, we're not going to do anything, then obviously there'd be a raft of claims, which, given the ruling that's already in place, the government would inevitably lose. So people aren't at any risk by not taking the claim on that point
Right.
now. So this really is about considering people who were affected, giving them the opportunity to be considered for any compensation if that is felt appropriate by the court.
Perfect. Alex, this one's come up as a result of our second video where you elaborated quite significantly on what the next steps are. What's the time frames, what's going to happen. And there was a little concern that came back off that in relation to communications you've been having with government, right? And I know we mentioned the date of around about the 1st of April 2022,
Yeah.
Yeah, and that sort of ties into when tapering would have ended anyway.
Yeah.
Right. So are you saying that the Federation's position is that, come the 1st of April 2022 or whatever date it is, we're quite happy that once government selected that date, everyone should flip over into the care scheme? Or are we actually saying that, when we entered into the pension changes and discussions back in 2012, we wanted everyone to remain on the scheme for as long as they want? So are you saying that we're rolling over and we're going to say, right, government, whatever date you agree, that's fine, move everyone over to the care scheme? Or are you trying to actually ensure that people are protected for as long as possible?
Well, I think we just need to unpick a bit of that. So there is no doubt that the Federation's preferred position was, is, and presumably always will be, ideally that people could stay in the pension scheme for as long as they wanted to. That hasn't changed. What we do need to recognise, however, is that there is not any legal case to oppose or to challenge people being moved from one scheme into a new scheme, right, when they're already in a scheme. That's well established, and there was no challenge. There's been no legal challenge on that particular case because there are no grounds to challenge it. That means that had, for example, on the 1st of April 2015, the government said you're all from that date in the 2015 care scheme, there would be no challenge. The challenge actually was around the transitional protections. The fact that they said to those who were older, later in service, you can stay over here and continue to benefit from this pension scheme, whilst your younger colleagues over here aren't being afforded the same protection. So when it comes to rectifying that, the government have got some choices to make. One is they say, well, we'll change our mind and you can all stay in the previous pension scheme until you retire, and that comes obviously. And
to be fair, that's really what members want.
Oh, it's what we all want. It'd be unless you're the government, because of course you go back to what was the rationale behind changing the scheme, and it was around affordability and cost. And the other option, unfortunately, the one that we don't want, but the other option for the government is you say, well, from this date, you'll all be in the new scheme. And as long as they've treated everybody the same...
Can I just stop you for a second? Because you mentioned new scheme, and you make me a little bit nervous, and I'm sure people watching this a little bit nervous. What are you talking a new scheme, as in...
No, sorry. It's new compared to the 87 scheme.
Right.
So 2015 is new compared to the 87 or the 2006 scheme. What the scheme of the future looks like, nobody's got a crystal ball. If there is a master plan, we're not aware of it.
Right.
At the best of our knowledge at the moment, when I talk about the new scheme, I'm talking about the 2015 care scheme. That doesn't mean that, at some point in the future, the government could say, well, actually, we're going to come up with a new scheme, either for the whole public sector or for the police service. We've seen that. We've seen that when they brought in the 2006 scheme and when they brought in the 2015 scheme. The only thing I imagine that's absolutely certain is at some point in the future, they'll bring in a new scheme.
Right.
But whether that's in 2 years, 20 years, 200 years, I don't know. I can say we have had no conversations at this stage with government to say that there is an intention to change what is the 2015 care scheme.
Perfect. Alex, just again picking up, around end dates, and you mentioned the 1st of April 2015. A lot of members, a lot of questions coming in is that what they really want is to be told, because of this discrimination and everything else, that they're on their pension scheme now, back in their old scheme, till the date that they retire. So, is this what it means for us? Is this, like someone like myself, am I going to go back into the 2015 scheme, sorry, not the 2015 scheme, the 87 scheme, until my retirement date? And I'm looking at a few years here, 2032 is when I'm due to retire. Is this what it means to me?
Unfortunately not, because that would have been everybody's desire. I mean, the Federation position's always been that people should be able to stay in the scheme that they originally joined, unless something better came along, until the time that they retire and they're able to take the pension. But unfortunately, what this actually is about remedying the discrimination caused when some people were protected and others weren't. And the way that's done is the government will need to identify a date in the future, whether that's the 1st of April 2022 or something after that, and make sure that everybody prior to that who was in the affected group gets treated the same. So that's about levelling up, if you like, for that period. And then from that date, everybody is also treated the same. And as long as they move everybody into a new pension scheme, and by new I mean the care scheme, because that's the new pension scheme as it stands, as long as they move everyone into that, they've complied with the requirements of the court. So whilst I'd love to be able to say, great news, old pension scheme forever, that's not how this works when it comes to rectifying the discrimination.
Next question we got is around a number of our members who are externally represented. So not part of this claim, but represented by Lee Day. And in the questions that we've got on the claim form, it's currently got, if you're represented by someone else, then you can't be doubly represented. You can't submit two claims.
Correct,
Yeah?
yeah.
So, I mean, most people get that. But then further down the Q&A, it actually says that if you are currently represented, you can actually be represented by PFEW. So there's confusion there. So what do you mean that you can be represented by two people at the same time?
No. If you've got a claim in, you're already a claimant, your case will be considered whether you should get any compensation, etc. So what you can't do is claim twice simultaneously, effectively, for the same one thing. So it's the same incident, effectively. What you can, however, do is you can change, if you choose to, who your legal representative is. And clearly that gives people who have got existing claims an opportunity to decide, do they want to carry on with their arrangement with Lee Day in that case, or do they want to change lawyers? And if they do choose to change lawyers and they want the Federation going forward to effectively cover the cost of that claim and instruct our lawyers, Penningtons, to represent the claim that's already in place, we will do that. That doesn't mean we're going to retrospectively cover the costs incurred to date, because obviously that took place outside the Federation funding agreement. But it does mean it's us saying to people, look, if you want to settle up with Lee Day and ask for us to pick up the representation through our lawyers Penningtons going forward, we can do that. Equally, if you're quite happy and you want to stay with Lee Day, carry on. Right?
So
but
just
it's the same claim. So your claim doesn't get pulled and put back in.
Right.
It's literally a change of lawyers, which happens. We've all seen it happen, I guess, in various court cases. From time to time, lawyers get changed, but it's the same case.
Right. So, just for clarity on that, you're not starting a fresh claim.
No.
Everything that's applied to your case at that particular point still remains. If any interim orders were made, in your case, up to that point, that still stands. All you're doing is progressing your case from that point onwards with a different solicitor.
Absolutely, you've got it.
Superb. Alex, almost at the end. A lot of questions from members saying they've signed up, they've got the initial email response back, but then they've heard nothing else. So what sort of time frame are we looking at before our members can expect, additional communications from PFEW or indeed from Penningtons?
Yeah, there was always going to be a delay. So we've got the form out, got the links out. I think we've currently got about 34,000 members who have registered. There's obviously a piece of work we now have to go through involving crunching our way through that data, making sure that, you know, if there's duplicate applications in, I think the record I've heard so far is somebody who's put in 8. So we need to obviously make 8 1 in that case. So what we've got to do is work our way through that. If there's any queries arising it, then obviously iron them out with the individual members concerned, and then get to a point where we can lodge those claims. So it was always going to take a period of time.
Right.
If you've had the acknowledgement email, be assured that means we've received your claim, we've got it. And we will be in touch. And because of the numbers, as you'd expect, what we will end up doing, I think, is putting out some generic updates at each stage. But we have got some time, bear in mind, before we move, or the tribunal obviously moves to hear the remedy,
Right.
not the remedy, sorry, the compensation type issues.
Perfect. And then you actually lead me nicely onto my last question, which is, you mentioned a member who's submitted 8 claims, probably because there's a lack of understanding in the questions, or they've made a mistake. A lot of people are really worried, you know, about making a mistake, because what you're doing is you're signing to agree that everything you're providing is accurate and the truth.
Yeah.
So what happens if I've filled out the form and I've made a mistake and I've pressed the submit button and I've gone, you know,
Yeah.
what do I do next?
Do it again. Right, and what we will do is we will take, so if there's multiple submissions from bread blogs, we will take the last, the most recent one. So the last one you submitted has been the most accurate.
Superb. So just resubmit the claim
Yeah.
with the correct details, and then you'll discard all the previous ones and take the most recent one.
Yeah, of course.
Superb. Alex, thank you so much for your time
No problem.
in relation to answering all these questions. Folks, we've tried to cover as many as we can. We are trying to keep these videos to around about 20 minutes, 30 minutes, a bit longer this one. So thank you for bearing with right up to the very end.